So, good morning, everyone, and thanks for joining me today as I talk about a subject that I've been getting a lot of questions on lately, which is just child support and what happens when a person's able or unable to pay child support. So starting from, well, first I'm going to try to introduce myself for those that haven't met me yet. My name is Angela Princewill. I'm a family law lawyer and a managing partner at AP Lawyers in Pickering, Ontario. And we help our clients resolve a whole range of family law matters. Well, our firm also has various other practice areas, but I spend 99.9% of my time in the area of family law. And I'm a mediator and a collaborative lawyer as well. So I have a whole range of tools in my toolbox that I use in assisting clients that come to us with various family law issues. So on today's topic, child support, what is child support? And in the simplest of terms, child support is just the amount that one spouse is required to pay to the other for the care of a child. That's the simplest way to put it. And this applies whether you are married or, or you're single or common law. So child support would apply for married people that are now separated. Same for common law. And even in situations where there was no cohabitation, you're required to still support the child. So for unmarried people, you would mostly be working under the Family Law Act. And for non-lawyers, this would not really, the difference wouldn't matter to you. But regardless, whether you're working, your child support is based on the Divorce Act or the Family Law Act, the provisions really mirror each other. So for the Family Law Act says every parent has an obligation to provide support to the extent that the parent is capable of doing so for his or unmarried child who is a minor, etc. So it is an obligation under the law. It's a standalone obligation to every parent to support their child. And the court can order you to do so, or obviously you could do so voluntarily. And what's the point of child support? Why is there, what's the child support for? So generally the purpose really is just to help the child financially. The legal system, or just I guess society as a whole, actually want to make sure that children are taken care of. And when when parents separate, we want to make sure that children suffer as little as possible financially. So in certain, the courts have set out, the purpose of what a child support order should be. And I like it. It's just put in very simple terms to recognize that each parent has an obligation to provide support for the child. So the fact that you're now separated doesn't mean that one person gets to do it alone. So that's the purpose of a child support order, and to apportion that obligation according to the child support guidelines. So the interesting thing in Canada is there's the child support guidelines. There's the federal one, which is, sets out all of the child support obligations for every province and territory in Canada. And there's the provincial child support guidelines. As I said earlier, they kind of mirror each other for the most part. And what the guidelines have done is they provide predictability. It makes it very easy. Parties don't have to resort to litigation to figure out how much they need to pay for support, and vice versa. The person receiving support can refer to the guidelines and understand if he or she is being underpaid child support. So the guidelines provide predictability and consistency across the board. It's just, when you look at the guidelines, there's tables there, the child support tables. You could look on those tables and see exactly how much you should be paying depending on what your income is. So that's the child support guidelines. Very, very useful. I like to see child support as one of those areas that are very black and white. When we're practicing in the practice of family law, almost every question you would ask is almost, it depends, it depends, it depends. It's not straightforward. With spousal support, we have we have the guidelines, but it's not it's not followed as and it's even arranged with the spousal support in any case. So it's not a fixed amount. Child support fixed, almost always followed, right? So if you are in the situation where you need to determine child support, well, you can just refer to the guidelines and you can include those provisions in your agreement. If you're in litigation, it could, go into, it will be in the form of an order, right? So what happens when you have that agreement or you have a child support order that's lower than what the guidelines say? Because there's times where I've seen agreements where people actually waive child support or include an amount that's way below the guideline amount. So what the court's simple answer is, you have to understand that it may not be upheld by the courts because it's not the guideline amount, right? So generally what the courts like to see is people following the guidelines. Now, if there has been a waiver, the courts would uphold it if reasonable arrangements have been made for the care of the child. So it's usually the exception. They want you to follow the guidelines as much as possible, but there's that recognition that there might be other financial benefits that a child is receiving beyond just getting the table amount of support. So under the Divorce Act, it's actually specifically said that, where reasonable arrangements have been made for the support of the child, the courts shall have regard to the applicable guidelines. However, the courts shall not consider the arrangements to be unreasonable solely because the amount of support agreed to is not the same as the amount that would have otherwise been determined under the applicable guidelines. So I know I said a minute earlier, the guidelines, it's almost always followed. It's very strict, again, predictability, consistency, but there's times when you might make, alternate arrangements. Could it be that, and I'm just throwing this out in the air, it doesn't mean it's necessarily a thing, but it's a thing, but it might not apply in the situation, and I recognize that. But let's say you're providing, housing, for example, to the child that completely eliminates the recipient from having to make child support, to having to make rent payments. Obviously, that's a benefit to the recipient spouse, but it would not, you might decide as a result of that to maybe set a child support amount that's lower than what's stated on the guidelines, right? So that would be considered a reasonable arrangement that's made for the care of the child, because they get that financial support from the payor, but it's not necessarily the guidelines. And, in some cases, it might even be arguable that if you quantify the cost of housing that the recipient is getting for free, it way exceeds, you might actually find that you're overpaying under the guidelines, okay? So the point of that is to say, don't just set a child support amount that is lower than the guidelines amount if the arrangement would not be reasonable. Because if a court finds that it's not reasonable, then you might find yourself in a situation where it can actually be set aside. So in the act, it says, if waiving that right to the table amount of child support would lead to unconscionable circumstances, then the court's going to set aside your agreement. If it favors one party, and if there's a default as well. So if you're not paying based on what you guys even agreed to in the agreement, then your that waiver or agreement to a lower amount could be set aside by the courts. So you have a child support obligation. It exists regardless of whether there's a court order or if you entered into a domestic contract or a separation agreement or something along those lines. It exists independent of that. So the fact that you have a child, the law makes it clear you have an obligation to support the child. There is the guidelines that make it easy to understand how much you should be paying for the child. So by trying to delay and drag things on without making reasonable arrangements for the financial care of the child doesn't take away your child support obligation, and you may be exposing yourself to a retroactive child support award, which just means that years into the future, someone may go back. You might get a judge going back several years to order that you pay child support that you failed to pay. And given a recent Supreme Court of Canada decision, you have to understand now that the law has been set straight that even if the child is a child of the marriage, nothing prevents the courts from going back retroactively to review the appropriate amount of child support and actually making you pay for it. Okay, so you know what your child support obligations are. You know what you should pay. You know that if you're not paying, you may be exposing yourself to an award for retroactive child support, and that could be a huge burden for a lot of people. But what happens when you're unable to pay child support, according to what the guidelines say, or even just what the your domestic contract says? That's a real possibility. And unfortunately, in the times that we're living now, we see that happening more and more, where people just cannot afford to pay support according to the guidelines. Well, this is where you refer to Section 10 of the child support guidelines, and its mirror provisions is the same in the federal or provincial child support guidelines. Again, the difference really is just if you're married versus unmarried, but for the purposes of this discussion, everything that applies is exactly the same. So under the guidelines, you can make a claim for undue hardship and a claim for undue hardship is just asking that the child support amount that you should be required to pay should be an amount that is different from what's determined under the guidelines if the court finds that by paying the guideline amount that you would suffer undue hardship. Now, recognize the word undue hardship, because there is always some kind of hardship when you have to pay child support. That's without doubt, right? You will suffer some sort of hardship, but it has to be an undue hardship. So what may cause an undue hardship? Well, the law has made it very clear some circumstances. Now, this is non-exhaustive, but these are certain circumstances that the legislature has said, if these exist, there might be some undue hardship. So where one spouse has the responsibility for an unusually high level of the debts, and so if you're, if as a result of your separation or whatever, you incurred a lot of debt, and you're the one that's bearing it, and this has to be debt that you incurred before the separation or, to enable you earn a living. If you have an unusually high level of debt and that affects your ability to pay child support according to the fixed stable amount, that could be a circumstance of undue hardship. The other is if a spouse has unusually high expenses in relation to exercising access to a child. And what that means is, again, just speaking from the heart, if for whatever reason, say the child support recipient has moved to a different country, and now, in order to spend time with your children, you're required to travel outside to another country. Again, it would be based on the facts of your case. So just having high travel costs in and of itself is not enough, but it's a factor and it's a circumstance that has been recognized that may cause you undue hardship. if you have a legal duty under a judgment or a written separation agreement to support another person. So this is an interesting one because the guidelines only show you how much you should pay, and based on your income, the province where you live in, and the number of children that you have, right? So if you, in a scenario where there's a first marriage, say with 2 children, and a second marriage with 3 children, the guidelines doesn't really tell you what to do in that situation. So if you consider that with on the same income, person A is paying child support to their ex number 1 for 2 children, they're paying the table amount, and now they're required to pay ex number 2 the same table amount for 3 children. You can imagine how that might lead to a situation where this person would have absolutely no funds left to just live, right? So that's recognized as a situation that may cause undue hardship, and you can ask for your child support payments to be altered in those circumstances. And the last case being if you have a legal duty to support any person who is unable to obtain the necessity of life for themselves. So, and it has to be another legal duty that you have to a spouse or somebody else. This list is non-exhaustive, so you may have a situation that causes you undue hardship that's not listed here. The courts would definitely consider that, but that's sort of what's provided in the guidelines or recognized in the guidelines as situations that may cause you undue hardship. So when you have a situation that's causing you undue hardship and you need to have your support amount reduced, and you come to the courts to get this done, well, what are they going to look at? The first thing they have to review is the standard of living test. They have to make sure that if you're requesting a reduction in your child support amount payable, that the standard of living in your home is not higher than that of the person that's receiving the child support, so the recipient, right? And a court must refuse your claim for undue hardship if the standard of living in your household, that's the person asking for child support to be reduced because of undue hardship, if the standard of living in your household is higher than the standard of living in the recipient's household. So this is very important, right? And you have to, there's actually a schedule online, and it's under the Justice of Canada website, I think, where it provides a schedule, and you can just go through that if you want to be very methodical in calculating the household standard of living ratio, and it just really tells you how to go about that. But when calculating the household standard of living, if both parties have repartnered, that's going to be a consideration in looking at the standard of living in both households. So before you make that claim, if you're suffering a hardship, but your standard of living is still, regardless of having to pay that table amount of child support, if your standard of living is still going to be the same or even more than the recipient, the child support recipient parent, you may want to hold off on making that application for undue hardship, because the courts must refuse your application under those circumstances. Most times, your success doesn't just depend on showing that the other party is living an extravagant lifestyle. I get asked that so many times. We live in an age of social media. We all know what's going on. You're seeing this post by the other parent. They're taking these trips. They're traveling. They appear to be eating out all the time. They're living it up, and you're wondering, she definitely doesn't need support from me. How is this even possible? Obviously, she must have a higher household standard of living than I am, because I'm just scraping by. So that in and of itself may not be enough, because you have to understand that when you do that math and you do that ratio, you might find out that you may still have a higher standard of living, and it's just the other person is choosing to leave the lifestyle that looks more affluent simply because they're prioritizing differently, or they just, they like to live extravagantly. But it doesn't mean that when you get down to the numbers that would not be helpful at all in showing that the other party has a higher standard of living than you do. Okay, so I just thought to put that out there because I know for a lot of people it's very concerning. And now that I mentioned that, I should tie it into something else that I hear often, which is the child support is supposed to be for the child, and it looks like, this other person is just using that money in ways that you probably don't approve. And there's that concern, should I reduce child support because she clearly doesn't need the money, or she's just not putting it to the right use. The answer again is no. If you are suffering an undue hardship situation, make sure that you articulate your claim. It's not based on how the other person is living alone. It's a factor, but their lifestyle has to be really higher than yours, and not just because they're living this life that looks more extravagant. It actually has to be so, in fact. I know that's not what a lot of people want to hear, but unfortunately, it's the law. We didn't make it, but we have to work within the legal framework that's available to us. Making a claim for undue hardship or meeting the test and being successful, in having your support reduced as a result, is a very high threshold. Again, so I keep saying it's undue hardship, not just hardship. And undue hardship has to be something that's exceptional. That's the words that are, used by the case law. It has to be exceptional. It has to be excessive. It has to be disproportionate. So the legal system, the judges, the courts understand that the breakdown of any, relationship or people cohabiting in and of itself creates a hardship, right? I always tell people that consult with me that it's cheaper for two people to live than one, right? Your household, your rent for one somewhat cheaper. It's much cheaper. Two can almost eat for the price of one, right? So it's cheaper for two people than it is when you're now having to run separate households. So there's that's recognized as a hardship, that it comes with the territory. It's a result of the breakup. It's unfortunate, but it's sort of accepted that there will be that hardship. But if you're going through something that's exceptional, and I know at this point there's a lot of people that are going through exceptional and excessive hardships, well, the point is you can make a claim for undue hardship if you're able to show that you really are going through something that's disproportionately hard and excessively difficult for you to meet your child support payments. You have to understand as well that you bear the burden of proof of making your undue hardship claim. So it seems like something simple and a no-brainer, but a lot of times people think that if they show that the recipient is living this extravagant lifestyle, and they establish that person is just living this extravagant lifestyle and doesn't need their child support payments while they are struggling to meet their expenses, they think that once they're able to do that, then the other person sort of has to show that they still need child support from them. It doesn't work that way. If you're making a claim for undue hardship, you're going to be required to actually meet every element of that test. And I'm going to go over it again, but you have to make sure you meet that standard of living test. You have to make sure that there's a circumstance of undue hardship that's actually happening to you, and it's actually an undue hardship in the sense that it's exceptional and excessive. Okay.